Welcome to the Art of Procurement podcast with your host, Philip Eidson. Here, thought leaders share the trends, strategies, and tactics that you can use to elevate the role of procurement and your career.
Hi there, everybody, and welcome to this week's Art of Procurement podcast, powered by SIG. And as you can probably tell by my voice, I've come down with a throat infection. So I'm going to try and keep this intro pretty short and sweet. I'm joined today by Jeanette Nyden. Now, Jeanette is a well-renowned contracts and negotiations specialist. Her work really focuses on building win-win sustainable agreements. And in fact, Jeanette was a co-author with Kate Vitasek and David Frydlinger of Getting to We, negotiating agreements for highly collaborative relationships. And she has a fascinating background as a trial lawyer, as a professional mediator, and then she applies that to her work. And so we spent a lot of time in our discussion focusing on Jeanette's background and some of the learnings that she has taken from standing up in front of many juries into the negotiation of contracts. So much so, really, that we didn't get to cover half of what I wanted. So you should definitely look out for a follow-up pod sometime in the next couple of months. We've got that in the calendar to record a follow-on. In my research for the interview, I heard Jeanette refer to herself as a deal junkie. And so in my first question, I asked what a deal junkie actually is, and then where for Jeanette did that passion come from?
So a deal junkie, I really like negotiating agreements. And I hesitate because the contract is one part of the agreement, the relationship, particularly as business relationships become more complex with suppliers and customers. I really enjoy the whole atmosphere of getting the relationship right, getting the contract right, having all the tools in place to be able to successfully establish a great customer-supplier relationship. And that's all I do. That's all I've been doing for a really long time. Where does the passion come from? I think it comes from my experience as a mediator. So if we go back a little bit, I have an eclectic background.
Right.
And at one point, I chose to do a professional mediation course as part of my continuing legal education. And I liken it to a longtime smoker who suddenly quits smoking and sees the light of day. I was a litigator in Chicago, which is a real bare knuckles brawl kind of place. Even in the federal courts, it's very contentious. It can be very strong types of leverage are used in the negotiations. And so I moved to Seattle and I take this course for my continuing legal education, and I learned an entirely different way of being able to reach an agreement, negotiate an agreement, and I became the converted, sort of like taking all the cigarettes out of my litigator friends' mouths, saying, do you know what you're doing to yourself? Do you know what you're doing to your clients? So I think the passion for me is that I can span the entire spectrum of negotiation from the most muscular court, leverage, judicial proceedings, kind of hard-nosed, bare-knuckle brawl kind of negotiating, all the way to helping parents write a parenting plan about who gets Christmas and even years and who gets Christmas and odd years, which is a very gentle, inclusive, very soft approach to negotiating in the best interest of the children. And I really combine that in my work.
There's a few things I actually want to drill down into, but I just want to jump off that comment to start with, and that's like, there's no such thing as a one-size-fits-all in so many things that we do. And obviously negotiating and contract negotiating is no different from that. But do you find that most favorable outcomes typically occur when you are thinking about, a relationship being part of that agreement versus those times when it's been all about the fight, it's been all about the power dynamics, it's who's got more leverage over the other? Or are there times when that's necessary, that you have to take that approach?
I'd say it's a 30-70 split. 30% of the time, you do need some muscle to move another party who is perhaps hiding information, being disingenuous, being dishonest, 70% of the time people show up and want to do a really good job for their organization.
Yeah.
And it's simply their organization's perspective, point of view, and business objectives don't align with what you think their business objectives, point of view ought to be. And that's where that collaborative process of communicating comes helpful, because if you use a really adversarial style, that is not going to necessarily change the other party's point of view, perspective, or business objectives.
Right.
It's only going to entrench them. And what we do know from research is that suppliers and or customers who are consistently bullied retaliate and or find themselves in a financially perilous position.
Yeah, they either take it and take what's not necessarily best for them, or you dig in your heels, don't you, and actually make it. I think we do that in all walks of life. You know, if you have somebody who takes that approach, you kind of want to make it harder for them to get what they want than if they actually come with a more collaborative, relationship-driven kind of purpose.
Yeah, I was just watching something, an FBI negotiator from actually the late 90s was being interviewed, and I know that there's a book on FBI negotiation tactics out there right now. Well, the name of it doesn't come to the top.
Was it Chris Voss?
My head. It might be.
Yeah.
But the point is that, you know, the harder you make it for someone to say yes to the position that you're taking through force, the harder you make it for them to say yes because of the force that you use. So you perpetuate a cycle. The more that you try to use leverage to force the other party to an agreement that they don't feel is in their best interest, the more force you need to use, the more likely they're not going to feel it's in their best interest, the more force you're going to use. And that cycle, to use an example from the auto industry from years back, really put a supplier such as AC Delco into financial straits when the economy stagned and they suddenly did not have the profits in the volume to sustain themselves. And it almost brought down one of the major automakers because of their dependence on this one particular auto supply manufacturer that had been divested from them. So this idea of forcing, because you've got a lot of leverage, a business deal onto someone that isn't in their best interest could and usually does come back to haunt you in some way.
Yeah, you mentioned the auto industry. That's where I started in my career, and started with a component supplier that had just been spun out from its parent. And we would often take that similar approach. And that's actually where I learned that this doesn't seem right. It doesn't feel like we should be using power and leverage as much as we do, because the supply base is so dependent on 1, 2, or 3 different suppliers. And they're never going to say no. And, you know, I don't think I saw that at the time, but as I grew and matured, you know, you start thinking ethically, is that the right thing to do? Should you be asking for everything, even if you know they're going to ask it? Even if you know they're going to give it. But also, is that sustainable for them? You know, you kind of got to look out for their own best interests, or for their interests, in service of the success of the contract you're trying to negotiate.
I think that the difference between how I look at a deal, because I include the relationship and thoughts around sustainability for the duration of the contract, is different than how old school buyers learned how to negotiate. The people that I encounter who have that experience of buying in the late 80s, early 90s, maybe even in the early 80s, so they're at the end of their career, have a perception that the suppliers are marking parts up 55 to 85%. Everybody's rolling in dough.
Yeah.
And if you don't take a muscular attitude towards price, you're going to get taken advantage of.
Yep.
But the circumstances of the supply chain in the last, let's say, 40 years have so dramatically changed that price conversation and those margins are out of context anymore. And what I mean by that is it's price and it's compliance in a global supply chain. It's price and it's sustainability around the developing world, and can we continue to count on parts coming from other parts of the world through their supply chain and their logistics organizations. And so this whole idea about price and margins, and that there's just this candy on the table to be discussed and divvied up, it is not as accurate. You might need more of a markup on one kind of part because of the way that it's manufactured, and for sustainability and for research and development for the next generation of the part. Other parts may not need very much of a markup, and you're simply paying for the logistical chain to get it from one part of the world to another part of the world. Those are very complex conversations that don't really lend themselves to a really easy, muscular, sharpen your pencil and give me your best price kind of attitude.
Yeah. No, that's right. And often again, this is probably how I was brought up in the early stages of my career, is the number is everything. It's the price. We didn't even really look behind the price, because it was easy to say it should be a different amount. It should be a lower amount because nobody's got anything to argue back on that. But it is just, it becomes a game, and you're not negotiating based on fact, but you're also asking for unrealistic things, often from suppliers. And maybe it's because you have a reason internally, you have margins to hit, but like you say, it's not really sustainable. I want to touch on a couple of pieces of your background. You talked about your experience as a mediator and also as a trial lawyer. I can only imagine the human element that's kind of necessary for being successful, both as a trial lawyer, but also as a mediator. It's not just about facts and data. It's about influence and persuasion and storytelling. And I just wondered if you could share perhaps some of the things that you took from those experiences that procurement professionals you think could really kind of learn from.
There are a lot of different aspects. I hesitate because I'm trying to narrow it down. The two things that jump to my mind is, yes, absolutely, persuasion and storytelling. So, for example, I have an entire section in my training manuals and in my first book, Negotiation Rules, about making the message attractive and the timing of the message. And that all comes from my trial experience.
Yeah.
How do you, when you give jurors and sometimes judges these facts that are sort of out of sequence, based on when a witness is available and all these sorts of things. So they get all these various facts, and then you have to pull it together at the end. How do you make that a persuasive argument? And what's the timing of how you make the message? So from a trial perspective, do you make it in a motion? Do you make it when you go to trial, et cetera? I was in court for 7 years, 4 out of 5 days of the week. So I really got very good at that concept. And so then I bring that to the purchasing organization in particular, because I think sales does this a little bit better, is how do they then use these techniques when working with stakeholders? So purchasing is a facilitator, and that's the mediator part of my background that I really draw on. So I've got this persuasion, messaging, timing of release of information that I'm very deeply steeped in. And then I've got this, but I'm a facilitator. It's not my decision. So when I'm a mediator, it is not my decision. I'm not an arbitrator or a judge. I'm there to facilitate a solution. Purchasing and sourcing, from what I can tell from my colleagues who are now leaders in those roles, CPOs, sourcing directors and things like that, they're saying even with the biggest of agreements, I am one part of the decision-making process.
Yeah.
There are multiple P&Ls that are touched by this decision. We all have to be happy with this agreement. I'm not a buyer anymore making a decision based on a spreadsheet price.
Yeah.
And that skill is not necessarily being drilled into the purchasing team as a whole. Some organizations do a better job at this idea around facilitation, that you are there to facilitate the best deal for the organization, not necessarily what you personally think is the best deal, because you have to take into account other stakeholders' perspectives, business challenges, timing, and things like that. So those are two very strong skills that I bring from both the trial lawyer and from the mediator. The other thing from the trial lawyer background that I teach, and I really teach this, and so for people who get this, it can really change how they negotiate, and that's a technique from being in the trial, in the courtroom, and that's called looping. So how do you take an answer that someone just gave you and loop in the follow-on question in a way that makes sense, but it's not random. Mm-hmm. It's to phrase the questions to lead the witness to a particular point. Now, I don't know how many hours of practice and continuing legal education, mock trial, symposiums where we practice. And then, as I said, I was in court for 7 years, about 4 out of 5 days. So I practiced it and failed and got successful at it. But the idea is that if you want someone in the negotiation who's a counterpart to see your point of view and you don't believe that they are seeing your point of view, you need to ask them questions that'll lead them to at least an understanding that your point of view is different from theirs, has a legitimate business reason, and ought to be considered by them as a legitimate business reason with a request. Mm-hmm. Now, whether they choose to accept it or not, you can't control that, but you can control the conveyance of the message. Yeah. And what I teach is, how do you use your questioning to lead to that realization, this is a legitimate business request with a legitimate business reason, and I can take it under consideration by my organization.
Yeah. What would some of the questions be that you would encourage listeners to the show to actually ask when they're wanting to do that kind of research or finding, I guess, of what the other party wants and what they're thinking?
It's not research as much as it's open-ended questions.
Yeah.
Some people, when they find out as a trial lawyer, I had one engineer who I was coaching who negotiated the technical specifications in aerospace, and he said, "Can you teach me how to cross-examine?" And I said, "No, because that's the exact wrong thing. I know how to cross-examine people, and unfortunately, my teenage daughter gets a little too much of it sometimes. Right. What do you mean you've been at the store?" But my purpose is actually a direct examination, and by direct, those are the open-ended questions where people get a chance to tell their story, and they're telling their story to the decision maker, the judge or the jury, and you, as the attorney, are there to create the roadmap. So you know going up what your questions are and how they're laid out, and you've got it in your binder at the podium, and you're ready to go. But it's a conversation. So you ask the witness the first question, and then they say something, and you pick up on it. Let me follow up with you on that, Philip. Let me ask you this particular detail, the way you did about the trial work. Let me drill down and let me get deeper into the whole time. If you're a trial lawyer, you have your questions typed up, ready to go in your trial binder at the podium. So at any given moment, you can look down and see, where do I need to go next? With this expansive conversation, right? It's got a purpose, it's got a direction. Yeah. So for negotiations, I often try to, when I'm mentoring is I sit side by side with someone at the bargaining table and negotiate the contract terms with the permission of sourcing and the legal team. And I'm there as someone who's doing this particular kind of work, either as a example. So watch me, Sally or Bob, watch me lead these next several sections of the conversation, see if you can do it. Or let's look at how you've established your roadmap for the conversation for this particular conversation, and let's see if you can do it. And by being at the table, it's a real-time learning, and my clients have gotten significant promotions as a result of being able to establish their ability to handle very big, complex deals and then now lead a team and things like that. So it's a very specific process to the negotiation. What I will say, though, is I touch on it in my first book, Negotiation Rules, where I talk about developing two kinds of strategy. Negotiators will pick up the big strategy. We need the best possible price and the best possible delivery and the best possible quality, and that's likely going to be either a European manufacturer or a U.S. manufacturer if we stay within manufacturing. So that's their strategy, and then they're ready to go. But what people are not doing is developing the strategy for the individual meetings and calls that matter. So the 3-hour call to discuss certain provisions, they don't have that strategy. They don't have the strategy to how to kick off the negotiations when everyone may be meeting for the first time and coming into the room. I don't want to start with the definitions, and we often do, and I advise all of my clients against it. Most of them chicken out, but the most successful negotiations are a roadmap. Let's sit back and let's tell you what our buying objectives are, why we down-selected you, why we think that you're going to be a great partner for us, and then you start weaving in, but we've got these concerns here, and we've got these concerns here, and I see you've got some concerns that you've noted, and you create the conversation so that you lead them to where you want them to be at the end of the conversation.
How do you determine how much information to share? What's too much, what's too little? Because I imagine you want to give them enough that they feel as though this is a transparent and a fair and an ethical process. But there's still that piece of you that doesn't want to give them everything, that they can turn and use that against you.
Yeah, that's the legitimate fear, is that information will be used against you. The third book that I co-authored with Kate Vitasek and David Frydlinger talks about the 6 guiding principles. And we talk about autonomy, and we talk about honesty as 2 separate principles. And these come into play with transparency, which is a core principle for establishing trust. And that is, autonomy is the supplier and the customer are autonomous, independent business organizations, likely held by shareholders, and as a result, they have a fiduciary responsibility to their shareholders to return a profit. So you have to see them as separate from you and not as a subdivision of yourself, whether you're the supplier or the customer, that you can just sort of tell them what to do and they have to agree to it. But what we drill down in autonomy is, but you can't really make good decisions from an autonomous business perspective if people are not giving you the information that you need. And so there's always this tension. Now, with honesty, what we decided to focus on from our experiences as negotiators, particularly David and I really had the lion's share of the thought and work around the principles, because we sit at the table so much and for so many years, is you need to be accurate. So honest can have an objective and a subjective quality to them. We wanted to focus on the objectivity. We always wanted to focus on, that's the part that you can control in a business organization. So can your information be accurate? Can your observations be accurate? Can your requests be accurate requests? You can control that. You can then control the fact that you are presenting information that helps this autonomous independent business organization make good decisions based on the accurate data that you're giving to them. That you can absolutely do. Now, with respect to transparency, that's not always an individual decision, meaning as a negotiator, and I learned this as a lawyer very clearly, I'm an agent. This is not my business when I'm a lawyer. I'm just a lawyer, right? Somebody else is making the decision. And so it's the decision of the business or the business unit or the business subdivision, such as a subdivision of sourcing that might be working on indirect spend. It's their decision about how much to reveal about strategy, purchasing, acquisitions of units, divestitures of units, things that could potentially impact the negotiations. And with privacy laws and trade secrets and heavy competition in industries, it's not our decision when we're in the role of a negotiator to second guess that our boss may not have given us permission to reveal that we might be divesting a unit, which could dramatically impact the result of the negotiations. It could happen, it could not happen. Until the ink is dried on that deal, we can't necessarily reveal it in this deal. And that's really hard for people who are not deeply steeped in the role of being a facilitator and an agent.
Yeah.
Because when you're steeped in, I'm here to facilitate the best possible resolution and I'm an agent, then you carry the message and you really can't second guess it because you probably don't have all the facts.
You know, there's a couple of things I wanted to just jump in on that you talked of, but one of them was about facilitation, and you just brought it up again there. You know, you said very early on that the role of procurement, and I couldn't agree more, the role of procurement, whether it's changing, whether it's always been like that, maybe there's just more acceptance that this is our role, is absolutely a facilitator. You know, we're not making sourcing decisions. We can make recommendations based on data, but we're always spending somebody else's money. And it's them that ultimately are making the decision of who they want to use, what they want to pay. You know, is that in service with their objective and the outcomes that they're trying to get through engaging with that supplier? You mentioned that you see some organizations who have been more successful than others in actually taking that mindset and using that approach when they're working with their stakeholders. I just wondered if you could share, you know, what are some of the things that you've seen that those organizations who have been more successful in taking that approach, are there things that they've done that have enabled them or, you know, increased their chances of success over others that are having more difficulty in doing that?
A couple things. One is, I think it's organic as a result of the change in the business employee community, meaning I'm seeing a lot more millennials coming into positions where they naturally bring a facilitative and collaborative and highly analytical decision-making process to the business organization. The business organization isn't teaching them that. That's just a good fit because that's how they're taught in U.S. schools and to some extent in European schools, and they're comfortable in a situation where everyone's discussing everyone's different needs and concerns, and because they don't have necessarily as much experience, they're also comfortable with sort of a group consensus as opposed to thinking, I have to be the one to make the final decision or I don't have any authority. So some of it is just happening because of right hiring and the mindset that they're hiring for. Organizations that I think are successful are the ones where the CPOs or the chief sourcing officers are openly developing a multi-pronged approach around this idea of facilitation, and they're talking about it at conferences. They're giving keynotes. Royal Bank of Canada at the ProcureCon Canada event in last year, sometime April, May, I think, discussed this very much, that what they were seeing in terms of the retiring of the baby boomers and the taking of the knowledge of all these years of working within purchasing and buying and then now sourcing. And they were leaving the organization and they were very conscientious about developing negotiation skills, communication skills, facilitation skills. They were conscientious about providing training, whether through their organization or through the International Association for Commercial Contract Management. They were very aware of the shifts that technology was going to bring to the market, meaning things that could be automated are going to be automated. So the simpler purchases that perhaps are still being made by quote-unquote buyers will eventually be completely automated to the best of everyone's ability. Where you maybe had 5 buyers, you might have one who's more of an administrative person to sort of check boxes and things like that. You don't need the other 4 to buy. Those 4 people are still incredibly necessary. They're necessary in these very complex deals, and they're aware of it. So I think that the organizations that are successful are taking the organic change in the market with the millennials, coupling it with an understanding of technology, and then creating the space for the organization to grow and change and adapt.
Do you see that those kind of shifts that are necessary. It's not just procurement, it's also a shift that's necessary perhaps culturally from a stakeholder perspective as well, because ultimately you can lead a stakeholder to take to a certain path, but if they're insistent on a certain approach, then it's still going to be difficult to achieve that. And so it's certainly more than just procurement having the mindset. It's also helping to educate those around us, those business partners, that this is probably a more effective way of going about things.
Yes and no. I think that there's so many conflicting interests, even within large organizations. You've got various stakeholders that have interests and business challenges and priorities that may trump another stakeholder's business interests and priorities. And that's where it can get very complicated in terms of having a truly collaborative negotiation internally with stakeholders. A colleague of mine and I are hopefully going to present at the National Contract Management Association on this issue, because she very clearly, in a senior position, has felt very that she's been in very muscular negotiations with colleagues of equal stature but in other divisions. And a big part of that is you can't take it personally, and some of it is we can't possibly know all the pressures that are on these various business units. So when they take a muscular position, it isn't that we take a muscular position in return, but it's how do we then use particularly these communication skills around having a roadmap for the conversation, opening up the conversation to see if you can explore the information that is relevant, knowing that there may be secrets. There may be things that person cannot tell you because it cannot get out into the general population about the strategic direction of that particular unit. And so we have to keep this really complex environment in mind. Can we influence? We can certainly do better than starting a deck with, and we're the gatekeeper.
Right.
And it was about 3 years ago I went in to analyze a small procurement organization, but a lot of money, hundreds of millions of dollars for R&D. And they didn't understand why the PhD engineers just literally went around the procurement department. Well, the deck introducing the procurement philosophy is a gate, and the baby boomer head said, we are the gatekeeper. So, we could do a better job of saying, we're here to help facilitate, and this is how we can help. But can we really change the stresses that other business leaders have? We know we can only work with them.
There's something else that, and this may seem like it's out of kind of place, the flow of the interview, but it's an important point I wanted to touch on from something you said earlier. When you were talking about both your experience as a trial lawyer, but also just in contract negotiations more generally, you talked about strategy, having strategy for individual meetings. You talked about having a binder of questions that are already kind of ready and you're ready to go. I think a lot of times, and I've been guilty of this for sure, you're turning up to a negotiation and you kind of think you know what you know when you're going in and you're winging it a little bit. You've got an idea of the outcome, but you're just going to kind of see how the conversation goes and maybe pull things out of your sleeve depending on how the conversation is. My question is, how much time should we really be spending on preparation rather than the actual negotiation itself?
Yeah, so I hear everyone's concerns and complaints really about the workload. I think that in the 15 years that I've been teaching, I have seen a dramatic increase in the workload because what's left on the plates of the people who I train now are increasingly more complex buys. I don't teach buyers anymore about buying. The buyers that I'm teaching are getting promoted to negotiate master purchase agreements, and so I'm teaching them contract language in it. So there is a real pressure on time. However, it's kind of that 80-20 rule. 80% of your time should be spent in a way that's going to get to the maximum result, and 20%, that last 20% may not get you that much more of a result. But when it comes to preparation, I think on the whole, we don't realize the fires we put out at the middle and end of the negotiations by not being prepared. I don't think that people really realize how many 11th hour crises can in fact be averted simply by being aware of what your own internal processes are for approvals and what you need to do now to get the conversation in a place where you can have a successful resolution without an 11th hour fire drill. Now, one of the tools that I use, and one of my clients, thought it was really important and tedious at the same time, is a really, an action log tracker. I mean, I just use this regular old spreadsheet because it was just so complicated between all the amendments, the scope of work, which was an entirely separate 100-page document, and then, a 300-page master services agreement. But we had too many issues going out to too many different stakeholders internally at our organization besides what we needed to track. And, it's tedious and time-consuming, but we also hit the deadline. We had to negotiate a $90 million deal that we found out that part of the business unit was going to close, radically impacting what the scope was going to look like, but we didn't know at the time what that scope was going to look like, so we had to negotiate scope decrease language and formulas and things like that because we couldn't know. And we had 4 months to get it done because the money for this project was held up in budgeting, and they gave it to us so late. We still hit the deadline, and we hit the deadline not only because we had a great team, but because Debbie and I, my colleague, and to some extent Liz, we were really good about keeping that action log up to date. And so at any given moment, if we were going to sit down and talk about insurance because our supplier was self-insured, and we had to really match our policies with their self-insured, and that was more of a technical getting it together rather than a hard-nosed negotiation. It was just massaging it all into place. But still, we had to keep track. What provisions were still open? What were we still looking at? Oh, that's right. We were going to take on hazardous materials. That's right. We need to do that. I don't want to go through and have that conversation 5 times over 4 months. I want to be able to track it. No, that's something that we got permission internally to accept as a responsibility, and then get those provisions in the contract, get the supplier to agree to it, get the insurance on our side to sign off on it, and so that when we presented it to legal as a complete negotiated package, they're really looking at how we dotted our I's and crossed our T's. And I think that we were able to do so much complex work, 8-9 hours on the phone with the contract up on the screen, because I had a couple different screens here at my office working the spreadsheet. So at any given time, if someone were to say to me, where are we on such and such? I could find that article, and I could find that, and I could say, oh, you said last time that you guys were going to look into that. They had a copy. We always sent it to them. We kept that transparent. We did not put comments in there that we could not share with our counterparts, and then we were able to share it. And so they, by the second or third version of this agreement, man, they were on top of it. They came and they would say, these rows are ours, we're still waiting. And then it was like, boom, we have a roadmap. Yeah. We know what we're going to talk about today because of the 10 rows that they needed to come back to with us. 5 are still outstanding. We know what the 5 are. So even though we didn't know what the 5 rows of action items that before 7:30 in the morning that we were going to address, at 7:30 in the morning we had a roadmap, and we knew by keeping track where that conversation was going to go. That's the kind of thing I'm talking about. I'm just talking about organization. I'm talking about, you don't let the conversation go where you want it to go. You'll talk about the same BS and go off tangent 40 times.
Yeah, it's kind of bringing project management principles, like looking at the negotiation of a contract as a project, not as something to do to consummate the deal. And, there's so many discussions I can remember where you just go off track and you look an hour backwards and think, what did I really achieve? We just talked about the things we'd already agreed. Or we talked about something for the 10th time because you hadn't actually kept a track of and a record of all the discussions and all the agreements as you went through it.
So a client of mine is a state government, and I'm working on this project right now. And when I got the RFP this summer, that was exactly the thing that struck me, is they wanted a professional who could combine purchasing, contracting, and project management. And that was the first time in my 15 years that I saw that in solicitation. And a solicitation from the government is the most lagging indicator there possibly could be. It's just, when you see that, you think we've all caught up, that there is a very much a project management approach. And because I have a project management approach that I've been coaching and teaching for a while, when I showed up at my interview with things like risk monitoring template, negotiation action log, tracking template, checklists for requirements, open-ended questions, because it all has to be detailed. But the way that I connect, well, if you've got this particular issue, then look at this acceptance procedure and then put it in your risk monitoring template, because that's going to be something that could potentially be a risk. When they saw that kind of level of organization, they openly told me that that's why they chose me in my company, because it really is, when you get into these big deals, keeping track of all the moving parts.
Right. So in the time that we have left to talk today, I just wanted to go dig deeper into a contract and the clauses within a contract. And obviously you're negotiating deals all the time. You're working with procurement organizations all the time to help coach, to facilitate, to mentor some pretty complex deals. I wondered if there's kind of clauses within a contract that you see procurement professionals struggling with on a regular basis, and perhaps what's some wisdom or guidance you can give us of how we could possibly approach those where we maybe make them a little bit harder than they need to be.
I'm actually going to take a different perspective.
Yeah.
It's not an individual clause, it's a emerging topic. And my most recent client is hiring me to talk at their global summit about this, and that's negotiating non-traditional clauses. So they've got buyers, and they have longevity in their organization. Most of them have 15 years on average. So they've seen the arc of supply chain change, but they're negotiating all kinds of compliance-related issues which do not have the same negotiation arc as price, delivery, quantity, quality. So it's not that purchasing is struggling with a particular clause. I think that there are a lot of incredibly savvy purchasing professionals who work with contracts that know indemnification and limitations of liability, as well as the colleagues in the corporate counsel's office. But I think that what's got everybody really concerned is, how do we negotiate GDPR coming out of the European Union? So you've got major companies, IBM, Microsoft, are on the stage at international conferences saying, we are going to implement GDPR globally, even in the United States, even with our United States suppliers. And that's where everyone is struggling. The stakeholders are struggling, the purchasing department is struggling, and the legal department is struggling to explain the nuances. So from my perspective, and so I've got clients who don't have GDPR, but they're states, so they've got a lot of regulatory issues, and they're also highly regulated industries for the public good, such as utilities, transportation agencies, electric utilities, things like that. Those clients are also struggling with the nuances and changes in the regulatory environment. And, sourcing wants to sort of take an attitude, or maybe even legal, hey, this is non-negotiable. And then the supply base is saying, then I can't be your supplier. And then the engineering team, for one example, is saying, well, then we don't have another qualified vendor. And that's where the bus stops. Because, in my opinion, everyone can take sort of a hard stance. The supplier can walk away and say, well, we literally cannot meet these requirements. And the supply side purchasing department can say, we must have this. And the lawyers saying, we must have that. But that stopping of business is profound and has a profound impact. And we I think, generally don't know how to see our way around that. How much do we give leeway for the supplier? How much is that a bluff? How much do they have to invest? Do we help them co-invest? Is that really our business to invest so that they can get their people certified to a certain level when that training isn't available. And I mean, it gets really very difficult very quickly.
Yeah. And so, in your experience, are those like roadblocks? And I've been there as well. I worked in a financial services organization, or an organization who became a bank holding company. And we worked on bringing the organization into compliance with all the rules of being federally regulated, and we weren't historically. And so we would take a pretty hardline approach as well in terms of contracts, that certain language had to be in a contract because we believed, or we took the position that it was a regulatory requirement, and perhaps sometimes it wasn't, but that was good leverage. That we looked at using that as leverage, perhaps. I guess my question is, do you see that when those impasses happen, is it typically because it's real, or is it typically because maybe all sides of the deal don't want the deal enough, and so they use that as a reason as opposed to trying to think about creative ways of getting what everybody needs?
I think that the parties are increasingly pressured and can't see a way out. So I'll use, I don't know financial, but I'll use the utilities and regulatory issues. If a regulation gets passed and the legal department feels that there's a tremendous amount of exposure and that the severity of the loss could be high as a result of not following this regulatory policy or lead, then it gets passed down to everybody else as this must be implemented. You must now have this exhibit H-1-A in your contract. And it isn't really explained other than this must be, this is policy, this is regulation, and this is what we're demanding. So there's pressure without a lot of understanding. Then on the other hand, you've got suppliers who are feeling increasingly squeezed. I think about that book, An Island of Green in a Sea of Red Ink, where there are places within suppliers and also buying companies, businesses that are more profitable than others. And those profits prop up the not so profitable units. They could be consistently not profitable, or they could be just periodically not profitable. So as a result, they start looking and saying, well, either we're already not profitable in this area, now you're asking us to do something that could potentially make us less profitable. You're asking us to do something that we're not set up to do, such as criminal background checks, which was a new thing a while back for one of my clients that some of their smaller suppliers just couldn't do or was too expensive. And so then the suppliers now feel pressured and say, we can't do this. This is going to ruin my business. This is going to ruin my profitability. And they don't fully understand it either. They don't fully understand the numbers. They don't fully understand the HR process. It's just it's policy. We can't do this. We shouldn't be working for companies that require this. So if these guys are going to require it, then let's go to another area where we are profitable or where we could be profitable. And it doesn't leave much room for negotiation. It doesn't get to a place where you can negotiate until there really isn't anywhere else to go. There are no other customers to work with, or there are no other suppliers to work with. But then you have to get the right people at the table, where sourcing and procurement now becomes the facilitator, because you've got to get policy to policy people in the room to discuss the nuances, because as long as it's being flowed down as a must without an understanding of what can give, that's not a negotiation, because the negotiation has to have some back and forth give and take.
Well, Jeanette, I know it's about time to start wrapping up. So first of all, before I just ask the last question, I really want to thank you for joining me today. I love kind of what you talk about, one, from a facilitation perspective, but also that relationships are part of an agreement. You know, we often lose sight of that, I think, and we just look at a contract and we look at the words and the numbers perhaps on the paper, but we forget of what are we really trying to achieve, and what is the outcomes that we're trying to drive towards. And the contract is only a part of that. And if we don't bring a relationship along with it, it really minimizes the chances of it being successful once it's in place. And I think those are things that, they just really stand out to me. I think of things that we as procurement professionals, I think we do, and we're increasing kind of how we think about that, but it's so critical. what I wanted to ask, and it's the easy question. I always say it's the easy question at the end. It's really just to ask if listeners who have heard our conversation today, that it's resonated with them and they'd love to know a little bit more about you, find out a little bit more about what you do, or even reach out to you directly, where can they find you?
Oh, thank you. My website is www.jnyden.com, jnyden.com. I also have free learning lessons. The subscription is free. It just means you get the 10-minute webinars when they come out. And that's www.newrulesfornegotiating.com.
Okay.
And the New Rules for Negotiating has articles and webinars and things associated with the webinar around contracting, contract management, contract negotiation. So people can get a lot of really valuable information without having to spend a lot of time or a lot of money that'll help supplement whatever they're doing in their daily work.
Perfect. Well, thank you so much, Jeanette. What I'll do is I will include those links. I'll also include a link to your LinkedIn profile. I'll put those on our show notes page for today's episode, and that's going to be at artofprocurement.com/Jeanette Nyden. That's artofprocurement.com/Jeanette Nyden. So one last time, thank you very much for joining me.
Thank you.
Thank you for listening to another episode of The Art of Procurement. To find an archive of all past episodes, you can go to artofprocurement.com/episodes. And to ensure you never miss another show, go to artofprocurement.com/subscribe.